My name is Rob Henneke, and I am the General Counsel and Litigation Director of the Center for the American Future here at the Texas Public Policy Foundation. And first of all, I would like to welcome you. Thank you for your participation in our 14th annual policy orientation. Before I get into the meat of our panel, I just wanted to introduce myself and what I do briefly, since what I represent is a brand new venture of the Texas Public Policy Foundation. This year, the Texas Public Policy Foundation created a litigation center called the Center for the American Future. And the reason for our litigation center stems from the recognition that so much of what we consider to be policy, so much of what the foundation has been the leader of for the past quarter century, is no longer being made in the legislative branch. So much of what we think of as policy is being made in the judiciary, is being made at the agency level through the executive rulemaking. And so this litigation center was established to advance 10th Amendment rights through judicial opposition to federal overreach and abuse, focusing on the subject matter areas of private property, environmental, and business autonomy rights types issues. So our mandate is to be proactive in advancing liberty through representing individuals who are threatened with government overreach and are unable to fight back, unable to muster the resources that are necessary sometimes to defend themselves. One of those examples is the case that I filed recently representing some ranchers up along the Red River here in Texas that are disputing the Bureau of Land Management's claim that their private property belongs to the federal government. But we're also looking for cases to be proactive in challenging government regulation that we believe it exceeds the lawful authority and it violates the Constitution. So we're here today to discuss our panel entitled Benefit versus Burden. Do the EPA's Clean Power Plan costs exceed the regulation's impact? And I'll go into a greater introduction here in a moment, but just briefly, I want to introduce our panel. We have, starting with my left, we have Dr. Cyrus Reed with the Sierra Club, the Austin chapter of the Sierra Club. We have Dr. Brian Shaw, who is the chairman of the Texas Commission on Environmental Quality. And we have Mr. Ted Hadzi-Antich from the Pacific Legal Foundation. The subject of our topic here today is the administration's Clean Power Plan, which has been adopted by the Environmental Protection Agency, and it claims authority under the Clean Air Act to set a national limit on carbon emissions produced from power plants. And presumably this plan will lower the carbon emitted by power plant smokestacks. And the final version of the plan aims to reduce carbon dioxide emissions from electrical power generation by approximately 32% within 15 years relative to the 2005 levels. The EPA's plan is focused on reducing emissions from coal-burning power plants. This plan requires that individual states meet standards with respect to reduction of carbon emissions to accomplish goals that are set by the EPA. And it depends on their energy consumption. And in the event that the state hasn't complied with the EPA's plan, then the EPA intends to impose a federal plan, a federal mandate. Currently, there are 27 states in the United States that have filed lawsuit challenging the legality of the Clean Power Plan, and that case is currently pending. The Clean Power Plan assumes, part of it assumes huge increases in renewable generation infrastructure. And to give some context, there's currently, 30 million megawatt hours generated through renewables. And under the Clean Power Plan, the EPA would have the United States generate 95 million megawatt hours through the renewables. This assumes that the Clean Power Plan is that the U.S. will be able to build and dispatch 6 times more wind and solar by 2030, which is an amount larger than any other nation's current wind and solar production. In fact, Texas is expected to add as much wind and solar as any other nation has now. Texas has the largest mass-based emissions rate in the country because we have the most successful economy in the country. But economy in the nation, but looking at mass-based emission rates is misleading. I think when you look at the rate-based emission rate, Texas has among the lowest emission rates in the nation. In fact, our position is that Texas is penalized under the Clean Power Plan for having such a prosperous economy. Forced closure and early retirement of coal-fired EGUs will cost billions. ERCOT here in Texas has estimated a 16% increase in electric rates and further estimates $31 billion in costs when you consider stranded asset costs, the cost for new transmission lines, and the cost for new infrastructure. ERCOT estimates the closure of 4,700 megawatt hours of coal-fired generation in Texas. But additional states may close due to the EPA regulation. With that being said, as an introduction, to have the first word, it's my privilege to introduce here today Dr. Cyrus Reed. Dr. Reed holds a PhD in geography from the University of Texas at Austin. I agree, with a focus on water policy. And he served as the Sierra Club's lobbyist on energy and air quality issues during the 2005-2007 legislative sessions. Previously, Dr. Reed directed the Texas Center for Policy Studies, which is an environmental policy and advocacy organization based in Austin, for 5 years. He's presently working on energy issues and their impacts. Dr. Reed has also worked as a journalist and spent considerable time in Mexico, Costa Rica, and Nicaragua. Please help me welcome our panel here today.
Thank you. It's a pleasure to be here. Thank you to the Texas Public Policy Foundation for the introduction. I think I'll probably be giving more of the minority report today in the sense that, as you probably can guess, Sierra Club is supportive of the EPA's rule. And I have 15 slides or so in 15 minutes, so I'll go pretty fast. But, you know, what I hope to cover in my 15 minutes of fame is why the Clean Power Plan? Why does this rule exist? A few facts about the rules, how much CO2 is produced from Texas, power plants, why reducing CO2 will also lead to health benefits from reducing other pollutants, and then talk a little bit about the current trends in ERCOT and why we believe that Texas is uniquely positioned to actually meet the requirements of this rule without impacting our very successful ERCOT free market, energy-only market, which is something actually Sierra Club agrees with the TPPF. We're in support of the energy-only market. And my conclusion is basically whatever the legal ramifications or the legal rule, which other folks will talk more about, you know, the lawsuits, we should go ahead and begin preparing a plan and ask for an extension so that's kind of the conservative thing to do. Have the backup plan if the rule survives, and I do believe in some way it will survive. Maybe not exactly the way it is today, but I think in some way it will survive. So you guys all know this, but the Supreme Court did rule in Massachusetts for EPA that CO2 can be regulated by the Clean Air Act. And if you believe in climate change, and I do, and most people do, and most scientists do, to deal with it, you've got to deal with emissions from existing power plants, because that's one of the top 3 sources in the U.S. of carbon dioxide. And we as a state have already spent a lot of money dealing with extreme weather situations and droughts, which are likely to become more significant as time goes on. So it makes sense to change our electric mix to lower our amount of carbon dioxide emissions and have those benefits. The other reason for the CPP, frankly, is international. The U.S. had to show it was serious on this to get other folks to the table. And one of the arguments against the CPP is always, well, why should we hurt our economy by doing this when China and India aren't doing anything? Well, by putting a plan forward, I would argue it had China come to the table, and the Paris Agreement, and it's not perfect, but it probably doesn't happen if the U.S. doesn't show leadership on doing something about climate change, and CPP is part of that leadership. EPA does estimate that the benefits, the climate and health benefits outweigh the costs. Others may disagree. And I would argue in terms of leadership, if we don't create this clean energy technology, we're going to allow other countries to do it. And Texas is an energy leader, so let's do it. We've done it. We've been doing it. Let's continue to do it. And I really think Texas is uniquely benefited to if we create a climate plan that's state-based. We can control our destiny, maximize our profits, qualify for federal grant programs, and frankly, we can sell natural gas, renewables, and efficiency credits, both within Texas and frankly to other states which are going to have a harder time meeting these requirements. So I'm arguing yes on Clean Power Plan. I won't get into the whole climate science, but this is just from a 2009 study just showing increased drought about, God, it's already 2016, about 84 years from now. So it's a reason to do something. A few facts about the rule. It does require a roughly 30% decrease in emissions from CO2. The Texas final goals, and this is Cyrus math, so don't quote me on this, but depending on whether we use a rate-based or a mass-based approach, we have a final goal somewhere between a 27 to 33% reduction from 2012 levels. You previously said 2005. It's, others can get into is the base year 2005, 2012, but what they actually put out in their fact sheets discusses 2012 levels, but it is a 30% reduction from 2005, but they use 2012 as a sort of a base. But it's in that range. It does require some interim goals starting in 2022, which was a change from the original rule. They made it a little more flexible, gave people more time. But this is important. They require states to submit a plan by September 2016, which is very, very soon and very fast, I agree. But they do allow states to ask for an extension. And that's something I would certainly encourage Texas to do, ask for an extension, because we're going to need it with the legislature not meeting until 2017 and significant need to coordinate between TCEQ, PUC, ERCOT, and others. But it does allow the EPA to step in and do a federal plan if the state fails to either do a plan or ask for an extension, or if they don't do the basic kind of stakeholder engagement that's required. It does create some extra credit, what's called the Clean Energy Investment Program, for those states wanting to invest extra in energy efficiency and solar, particularly for low-income communities. So that's something we could take advantage of if we had a plan in place. And then it gives us a lot of flexibility on, do we want to have specific performance standards for each fossil fuel plant? Do we want to have a mass-based state goal approach? Do we want to have a rate-based approach? And if I have time, I'll talk about this in a little bit more. Or do we even want to talk to other states and have a multi-state approach where we allow trading across multi-states, Arkansas, Louisiana, other states? So those are all things that could be decided over the next couple of years, but we would need to submit something in September so we can control our own destiny. Probably hard to read all this. I just wanted to say some of the things you might hear from some of the folks, I'll just say I don't think are true. I don't think Texas was treated unfairly. We are the largest CO2 emitter, and partly it's because we have a big successful economy, but we do produce a lot of CO2, and so having to make some large cuts, 27 to 33%, I think is appropriate. The final rule was kinder to Texas. The reductions required in the initial version of the rule were more severe than the final rule. EPA, to come up with these proposed reductions, came up with building blocks, and in the final rule they used 3 building blocks, which were making our coal plants more efficient, dispatching our natural gas plants more, and increasing the use of renewables. We don't actually have to follow those building blocks. Those are only the way they calculated those interim and final goals. So it's not that we have to follow those exactly and have to exactly come up with 3 times or 6 times the amount of renewables as we have today. That's just how they calculated the numbers. I frankly think the building block assumptions are actually achievable, and I'll get into that in a little bit, based on current trends. And there's also this notion we don't get credit for what we've done. Well, the wind investment that we've made, all the wind out there that's producing emissions-free megawatt hours, does help us get there. So maybe we don't get a specific credit for this specific plant, but if we go rate-based approach, those megawatt hours go into the denominator, sort of, you know, the pounds over the megawatt hours, so that helps us get there. And even if we go to a mass-based approach, if you assume that wind, solar, and more efficient gas plants are running more, you're going to have less carbon dioxide emissions. So I think we do get credit for the investments we've already made in more efficient gas plants, more renewables. You know, this is my Spider-Man quote, with great power comes great responsibility. We're the big kahuna in CO2 emissions. This is from 2013 numbers, about 260 million tons of CO2 from our gas and coal plants. So we've got to make cuts. If you're serious about climate change, you're going to have to make cuts. So we're the big kahuna, so we should do something about it. With those CO2 emissions from those plants also come significant SO2 and NOx emissions, which obviously lead to health issues and lead to ozone formation in our cities. So to the extent we decrease the use of some of our oldest and dirtiest plants, it's also going to help us in health and complying with other EPA regulations like regional haze and like ozone. So there's sort of a co-benefit when we do both. Most of our CO2 emissions are from coal, about 62%, 38% gas. Frankly, about a third of our total emissions are from our oldest and dirtiest coal plants. So let me talk about first let me give the pro-Texas, you know, for some of the legislators here in the audience. We've done this before, right? We've created Texas programs that have worked without the federal government telling us how to do it. We created TERP. It's been, and thanks to Brian Sean, the TCQ, we have reduced emissions from transportation by a lot because of the Texas Emission Reduction Plan. We already have energy efficiency programs through some great work done by both Speaker Strauss and then Senator Corona. We have reduced NOx and SOx from old power plants when SB 7 was passed. When we did the Renewable Portfolio Standard, we created goals that we've, you know, really tripled what the requirements were. So we've set goals before, and we in Texas have done this. And so I don't think it's any different if we come up with a plan that we can come up with a plan that works for Texas. This is 2015 numbers. Already coal is, in 2015, is significantly down, gas is up, wind is up. The trends are already going the way that the CPP tells us to go. Skip that one. This is what's in the queue, in the ERCOT queue. It's gas, it's wind, and it's solar, and a little bit of storage. The one coal plant is the former Dallas mayor, is the, you know, out in Odessa, is the carbon capture coal plant. So what's being built in Texas is exactly what's kind of required in the CPP. Wind, solar, and gas are going to be the main components of our energy mix. Wind's still growing. We're at 15,000 megawatts. The ERCOT queue shows us getting up to about over 25,000 within 2 years. So the trends are there. Solar is significant. Austin Energy has just signed 438 megawatts in that range per megawatt hour. The trends are there. Compliance, mass-based, rate-based, performance-based, multi-state programs. It doesn't require any specific plants to retire. It just requires that carbon emissions come down. So how we use trading programs or other market-based solutions doesn't require any particular plant to retire. It just requires that overall we go down. 2 minutes. And plants are facing this right now. Within the U.S. as a whole, we've had 225 coal plants either retire or announce retirements. This is the way things are moving anyway. Utilities are making this decision today, even without the CPP. Let me just kind of sum up ERCOT's own analysis. and it was announced that it would cost $31 billion. They actually looked at 4 scenarios about compliance with Clean Power Plan. The $31 billion is kind of the worst case projections. If you look at their baseline already shows more wind and solar and combustion turbines being built and a little bit of retirement. What they show with the CPP is if you just do the limit, we can do it without retirements. If you have an actual CO2 price, there probably will be some retirements. But I think the trends are, what I'm suggesting is the trends are already there. There are other solutions that we as Texans could have. I'm part of a ERCOT working group that's looking at allowing loads to bid into SCED and into our real-time market. It's called Loads and SCED. Sounds like a punk band, but it's a real working group. Energy efficient, our current programs could be expanded. Because of the great work of the Texas legislature, we just approved new building codes, which will require new construction in Texas be more efficient. I think we could get credit for that. For all the new buildings going on with the 2015 Texas Energy Performance Codes, I think we could get credit for that under the CPP if we're smart. Energy storage, distributed energy resources, there's a discussion in ERCOT how to allow distributed resources, both, you know, self-generation, gas or diesel, but also solar, to actually bid into the market as well. So we can come up with solutions that are market-based that will help us get there. And we already have the Energy System Lab already kind of keeps tabs on how we're reducing carbon dioxide, or at least they have the modeling to be able to do it. With all our programs, utility efficiency programs, building codes, new air conditionings, we're already getting significant reduction. If we can actually make sure we've got somebody counting the beans, we can get credit for it. So my conclusion would be there are health and economic benefits through CPP compliance. We've met big environmental challenges before. We should be embracing these new sectors and new technology. My time's up. We can take advantage of what we have. And even as the state sues, and I recognize what state I'm in and that we're going to sue and there's going to be lawsuits, we still should submit an extension request in September of 2016, do the basic things we need to do, which I know Brian Shaw and others are capable of doing, and get prepared. And then we have time during the legislative session to prepare ourselves if the CPP continues as law. And I would expect, even if some aspects of it get struck down, that some part of it will remain based on the previous Supreme Court decision. So that's, I took 16 minutes, sorry, but I did my best.
Thank you, Dr. Reed. And now it's my privilege to introduce Dr. Brian Shaw. Dr. Shaw was appointed to the Texas Commission on Environmental Quality by Governor Rick Perry on November 1 of 2007. He is an associate professor in the Biological and Agriculture Engineering Department of Texas A&M University, a former associate director of the Center for Agricultural Air Quality Engineering and Science. Dr. Shaw served as the acting lead scientist for air quality and a special assistant to the chief of the U.S. Department of Agriculture Natural Resources Conservation Service. He served on the Texas Environmental Flows Advisory Group and as chair of the Texas Advisory Panel on Federal Environmental Policy. Please help me welcome Dr. Shaw.
Thanks, Rob, and thank you to the Texas Public Policy Foundation for the opportunity to be here and to address and talk about this issue, which is probably one of the most far-reaching environmental regulatory initiatives that we've seen, and maybe hopefully we'll ever see. I want to talk about a number of issues. I'll try to keep it on my schedule there. Dr. Reed did bring up a number of issues that I wanted to address, and you'll see some. I think it will help to show some of the differences between where the viewpoints are coming from. Let me start off and express where I think is appropriate to give you some background, the appropriate viewpoint or lens for a regulatory agency to look at when considering and evaluating a federal rule that comes out. And I think it's important not just for me as a regulator to look at it through this lens, but I think also it applies to fellow Texans, to other interest groups, even environmental interest groups and just the industry groups should look at not just whether or not the rule does good things for you, whether it's more appealing than the proposed rule, we have to make sure that we look at the longer haul. And part of where I think that problem becomes really obvious with this rule is if you anticipate and see some of the rhetoric that the final Clean Power Plan was much more favorable for Texas than the proposed, and therefore we should be happy. I think part of that, we want to be careful not to fall into the trap, because some of the biggest concerns that I have with the Clean Power Plan are not just what things it's going to do from the standpoint of the cost benefits and the energy reliability in the state of Texas. Those are big and those are huge. But there are other issues as well, and that is that this would fundamentally shift authority that has been rightfully given to the states, especially from the standpoint of energy policy. This rule, and I understand, as Dr. Reed talked about, EPA has indicated that you don't have to use any of these specific building blocks to get the reductions that they're targeting that you have to get. The key is you have to get and document those reductions. The key thing that you have to understand is if you look at what tools are available and you look at those building blocks, you pretty quickly realize that you can't get there without implementing most, if not all, of those building blocks. And more specifically, I think it becomes really clear that you can't get there without significantly reducing your coal-fired power plant fleet, which in and of itself is maybe some people would agree with that. Certainly there are some people who would benefit from that, but it doesn't fall into the legal bailiwick, if you will, of the EPA. That's an energy policy. That's something the state of Texas, especially as one of the states that does have one electric grid that's completely contained within the state, and so there's no cross-state commerce that brings the Commerce Clause into play. We have the rights to mandate and operate that energy policy within our state. What this would do would be mandating that EPA has dictated not just what reductions are accomplished through their analysis, but would indicate what energy policy looks like. I'll talk about that a little bit from the standpoint of if you look at the way that EPA's approached the 111D, which is the fundamental underlying statutes that authorize the EPA to regulate greenhouse gases from stationary sources, in this case, electric generating units. Where they get that authority is they have the opportunity and the ability to assess those plants that are being regulated, in this case coal-fired power plants and natural gas and oil-fired power plants, to assess them and determine best systems of emissions reductions. What that has historically always meant is EPA was able to look at what controls could be put on those facilities and determine what reductions could be achieved in a reasonable manner that would consider the remaining useful life of those facilities. Effectively, the way that's always been done is you would look at those facilities, for example, a coal-fired power plant, and you would see what kind of controls can be put on, what kind of reductions can be attained without putting that out of business unduly early in consideration of its remaining useful life. And in this case, that accounts for, depending on the state, in the state of Texas, I think they finally adjusted this down. Initially, that was going to be a 6% improvement they thought we could get, and now they've more reasonably assured that, as I think it should be about 1%, I think they used 2% in the final rule, that there are maybe some opportunities for additional energy efficiency. That is, that getting more electrons down the wires for every BTU of coal or natural gas or oil that you burn. What they've done, though, is they realized that that would not get anywhere near the 30% threshold that they were hoping to obtain, and so they decided to give states flexibility. That flexibility is where they brought in these other building blocks. They're going to make us do other things where you dispatch not based on cost of electricity, based on the cheapest form of generation, but instead based on greenhouse gas emissions. What that has led to is an energy policy change that now has the federal government choosing what type of energy mix we have in the state of Texas. This would be somewhat similar if you were a farmer or rancher and you were raising chickens and the federal government said, we don't want you to raise chickens anymore, we want you to raise pigs. And you could argue that people who are in the pig business would benefit from that. And that's sort of what they've done is you talk about, well, Texas is going to benefit because we're going to have this renewable energy market that's going to be growing. That may be true. There would be some beneficiaries of that, but it's not the federal government's role to pick the winners and losers. It's the federal government's role to follow the rules and the laws that have been passed and follow those appropriately. In this case, they don't have the authority to do that, in my opinion, and that's one of the huge issues that fundamentally would change and shift the way the power between the states and the federal government occurs. I think it's also interesting because if you look at this building block approach and this flexibility they gave states, supposedly, which basically increased about a tenfold, in my view, increase of what Texas reduction requirements would be compared to what those reduction requirements would be if EPA followed the law and only applied what controls could be put on the facilities being regulated. So we get about a tenfold increase in how much reduction we have to have, but it cost us a great deal to get there, and that's really not a true flexibility, and it's certainly a flexibility that we cannot afford. And so as you look at that loss there and you look at the implications of that, is you see that Texas is put into a situation whereby we were looking to scramble to do things that we're already doing, and you hear a lot of rhetoric that Texas is already on that track. And I agree, we're already making huge benefits if your goal and your metric is what's happening with the renewables. We're growing very fast, we're a leader in that area, and we've done it through what I think of as the plan that Texas already has. And that's a market-based approach whereby we're looking at using our energy resources that we have to develop the next level of energy resources. And if we can continue to do that, to be able to burn coal cleaner, to be able to implement renewable energy as it makes sense and let the market ferret that out, I think that's the Texas plan that has been working well, and we need to continue to work along those lines. To the extent that Texas is already on that path, and some would argue, well, why do you care about this EPA plan? Because you're already headed down that path. I would say, why would you turn over 30 years of historical application of this rule, this legislation, this statute, in order to accomplish a very minor increase? And I think that's something that I'll talk about a few details to kind of characterize what that actual benefit is. First of all, from the standpoint of where the numbers are coming from, EPA initially talked about a 30% reduction by 2030. That was based on 2005. It was a 30% reduction from 2005 levels, but they used 2012 as the baseline. What they did, in other words, because they show a much bigger increase in, or much greater decrease in emissions if they use 2005 as the base year, because there's a lot of things that happen to reduce greenhouse gases between 2005 and 2012. But the reason they didn't use 2005 as the base year and the year that they do the calculations from is because they wouldn't be able to require as many reductions. In other words, they didn't want to give credit for all those things that happened between 2005 and 2012. And so EPA is the reason for this confusion, because they came out with a rule and they said 30% reduction from 2005 levels, but then when you read into the rule, you see they actually used 2012 as the base year for calculating targets. And so as you see that, you think about, why does this matter? Well, if you look at the benefits that are associated with this rule, you have to look at the costs associated with it as well. But in EPA's own language and description of what the benefits of this rule are, they can't put in numbers and dollars to the actual benefits of this 30% or 32% reduction in greenhouse gas emissions from the U.S. because the implications based on their own models, their best case models, are so small as to make it impossible to calculate benefits. What they instead have done is looked at the environmental cost of carbon, which is basically sort of a fudge number that they've said that we think carbon overall is costing a certain amount per ton, and that's not based on specific benefits. They can't bring those benefits because if you look in the rule, the benefits they cite to based on those reductions are a 0.01 degrees Celsius decrease in temperature rise and the decrease in sea level rise about 3 sheets of paper thickness. That is the environmental benefit. And I would challenge any of you to characterize and quantify and validate an environmental benefit associated with 1/100 of a degree Celsius lack in rise in temperature and 3 sheets of paper in sea level rise. They couldn't do that either. And so they basically do a lot of other things, which is where the co-benefits come in. And I'm only going to spend time on this because it's a very problematic approach that EPA uses repeatedly. And that is, the greenhouse gas benefits are largely from co-benefits. That is, they're assuming that by this rule shutting down coal-fired power plants and other generation sources, they're going to reduce particulate matter largely, but also NOx and SOx as an unintended beneficial consequence of that rule. And so every time that they would model then that a coal-fired power plant is going to be closed down, they then say those particulate matter emissions are off the chart. Here's one problem with that. In the state of Texas, we don't have anywhere in the state that doesn't meet all the particulate matter standards. So we don't have anywhere in the state of Texas that EPA says that our rules need to be reducing particulate matter to provide for health of the ambient air. Yet whenever they apply these rules and these benefit analysis, they assume that we're saving lives by reducing particulate matter below the levels that they've already said are protective. So that's very problematic, and they do this through a number of rulemaking, but you have to look at any of the benefit calculations because they do particulate matter over and over again, and it's the largest area in all the rulemaking that's happened in the last 10 years. It's very prevalent, and I'll share this just to put a fine point on this particular issue. And that is, if you look at the study that EPA did on the benefits of the Clean Air Act from 1990 amendments through 2020, they calculated a $2 trillion benefit associated with all the Clean Air Act. In that process, I believe the number was about 85% of those benefits were associated with reductions in particulate matter. So what's happened in the past and what they perceive is going to happen between then and 2020, 85% roughly of all those benefits was associated with particulate matter. Of that, 99% of that 85% was reducing particulate matter 2.5 below the standard. So they were assuming that you were going to get health benefits by reducing particulate matter below the level that they say is protective. I think that's something that is fundamentally bad government, and it leads to bad decisions, and it makes it appear that a regulation that is going to be very costly is indeed, that's going to be very beneficial is indeed actually very costly, with the benefits being very difficult to quantify and, in fact, somewhat questionable at best. So I'll talk a little bit now about some of the things that Texas has going from the standpoint of the CO2 emissions. Yes, we are the big kahuna with regard to CO2. Texas is also the big kahuna with regard to petrochemical input, and we provide, I think, some 40% of all of the petrochemical-based products to the rest of the country. We are a large component of what is driven through the energy and the petrochemical universe of the United States. And so it is true that we are large emitters, but we're also making great strides to do things in a more energy efficient manner. And I think what we have is an approach whereby we're looking at how do we approach environmental issues from a standpoint of making certain that we're not just doing something to feel good about it, but we're doing something that will have long-term and lasting improvement. And I think that's where we miss out when we sort of tell ourselves that greenhouse gas emission is something that we need to sort of ignore the rule and the law and the history of how we've applied things and do something different just because we need to make some input on greenhouse gases. That's a very dangerous process when you suggest that you're not going to follow the letter of the law and the meaning of the law and the history of the way you've applied these regulations to get an outcome that you want, because you have to remember that when the people you agree with are in office, you want them to do that. But whenever the tables are turned and someone who has different values and different benefits comes in and says, well, the predecessor didn't feel constrained by following the rule of law, feel constrained by following what legally they can do within the regulations that are in place, they're not going to be moving and using that flexibility, if you will, in the same manner that you want them to do today. And I think in order for us to maintain the nature of our country and the benefit that we have, where we have a strong rule of law, where we have opportunities for us to really have a market that is driven to provide jobs and goods and services, but also to be able to find economically feasible and most efficient methods of obtaining environmental benefits, we bring all that into question. And I think that's the heart of the concerns that I have from the standpoint of the Clean Power Plan, is it fundamentally shifts that authority that the states have. And as you look at EPA taking unwarranted and unauthorized privilege with regard to the Clean Power Plan, it's because they want this outcome so much that they're willing to ignore what legal authority they have. And that's a very dangerous precedent to set. And I'm certainly proud to be in a state that recognizes that if we don't have the authority to do something as a regulatory agency, we don't do it. And that's something that was very stark in the meeting I was at recently, where it was clear that a number of states, as well as EPA, were talking about how there was questionable authority in certain things. One representative from California, one of my colleagues from California indicated that with regard to this, they don't get caught up in whether or not it's legal. They are focusing on doing the right thing. That's a very, very dangerous precedent, because what I think is the right thing may not be what you think is the right thing. And so I think it's important that we have these discussions, and I thank you for the opportunity to be a part of this discussion with you this morning. Thank you.
Dr. Shaw, thank you very much. Our third panelist, a friend of mine, is Mr. Ted Hadzi-Antich, who is a senior environmental attorney at the national headquarters of the Pacific Legal Foundation. Ted is PLF's lead attorney in Clean Air Act litigation. Most recently, he's challenged federal and California greenhouse gas emission standards on a variety of constitutional and statutory grounds. He's been an environmental lawyer for almost 40 years, and he practices in the areas of Clean Air Act, the Clean Water Act, the Endangered Species Act, the Resource Conservation and Recovery Act, the National Environmental Policy Act, and other federal and state environmental laws. Ted, welcome to Texas.
Thank you very much, Rob. It's a pleasure to be here to address this 14th annual policy conference. I'm a lawyer, as Rob indicated, so I'm going to talk about the legal issues involved in the Clean Power Plan. And I'm going to focus on the legal challenges currently pending in the United States Court of Appeals for the District of Columbia Circuit. But before addressing the current legal challenges, I think a little bit of history is important. Back in 2005, an environmental advocacy group petitioned the U.S. EPA to promulgate regulations governing greenhouse gas emissions from mobile sources. It's important to underline the petition was for mobile source regulation of greenhouse gas emissions only. EPA did not act immediately within the time frame required under the Clean Air Act to address the petition, and the only thing that EPA needed to do was to determine whether it would or would not promulgate mobile source emission regulations. And so the Environmental Advocacy Group sued EPA in the D.C. Circuit, and it went up to the United States Supreme Court, and in 2007, the Supreme Court decided in the case that many of you are familiar with, Massachusetts v. EPA, that indeed greenhouse gases did constitute an air pollutant under the Clean Air Act, and that consequently EPA had the regulatory authority to regulate greenhouse gases. But one thing, there's some confusion on this issue. The Supreme Court did not say that EPA had to regulate greenhouse gases. The only thing the Supreme Court said is that it could if it so chose. So 2007, Massachusetts v. EPA, under the Bush administration, comes the Obama administration starting in 2008, and the Obama administration took this Supreme Court ruling and decided to act positively, if you will, on the original petition and promulgated what's called an endangerment finding, a finding under the Clean Air Act that greenhouse gases pose a danger to human health and welfare. And that endangerment finding immediately triggered two separate sets of regulations governing mobile sources, one for cars and light-duty vehicles, and the other for heavy-duty and medium-duty trucks. Now, I've got an outline that's been handed out, and I am following that outline. So we're in the car rule and truck rule portion of the background discussion in Roman numeral 1. To make a long story short, historically, challenges were filed to the endangerment finding, to the car rule, and to the truck rule. And all of those challenges were unsuccessful going up to the Supreme Court, except for one particular piece of the litigation. Because what EPA did is it determined that just as the endangerment finding triggered regulation of mobile sources, the regulation of mobile sources under the Clean Air Act in turn triggered the regulation of stationary sources under the Clean Air Act. All of the power plants, if you will, that are our discussion of this session, factories, apartment buildings, schools, all of the stationary sources were triggered also under certain provisions of the Clean Air Act. And it's that case that the Supreme Court brought up in what's Roman numeral 1D of the outline, and this is a very important case for our future discussion today. It's called Utility Air Regulatory Group versus Environmental Protection Agency. And the specific issue addressed by the Supreme Court in that case is significant. I'm just going to read it very quickly. Whether it was permissible for EPA to determine that its motor vehicle greenhouse gas regulations automatically triggered permitting requirements under the Act for stationary sources that emit greenhouse gases. The answer that the Supreme Court gave to that case, to that question, is a resounding no. There was no automatic trigger for stationary sources merely by virtue of the fact that mobile source regulations were put into place. And some of the language that the Supreme Court issued here, this was a case authored by Justice Scalia, informs our judgment as to the future of the Clean Power Plant challenges. That language is as follows. When an agency claims to discover in a long extant statute, here the Clean Air Act, an unheralded power to regulate a significant portion of the American economy, we, the Supreme Court, typically greet its announcement with a measure of skepticism. And then the money quote, we expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. And so the question for us today is whether the decision to promulgate the Clean Power Plan is a decision of vast economic and political significance. I think you can all judge for yourselves. The prior speakers established the fact that a 30% reduction in greenhouse gases is required by the year 2030. One of the things that wasn't covered is that many economists and technical people familiar with the energy industry say that that 30% reduction is going to be only achievable through a massive change in the kind of resources that are used to generate electricity, away from fossil fuels such as coal and towards renewables such as wind and solar. And because of reliability issues, what that's going to cause are blackouts and brownouts and a tremendous increase in energy costs for each one of us. And so the question that the Supreme Court posed in Utility Air Regulatory Group is this particular regulation one that causes vast political and economic impacts? The answer is certainly yes, and that's as a factual matter. One is entitled to one's own opinion, but not one's own facts. So we go on to the challenges. The Clean Power Plan has two components. One, regulation governing existing facilities, and the other regulation governing the construction and development of new power plants. Both of those were challenged in the United States District Court, in the United States Court of Appeals for the District of Columbia. That's a required venue for these kinds of challenges under the Clean Air Act. 41 individual petitions were filed challenging these rules, and within those petitions, there were 150 distinct petitioners, and as Rob indicated, 27 of those distinct petitioners were individual states. In addition to the states, there were a number of state regulatory agencies that independently challenged the Clean Power Plan. What are the arguments that are being used in the District of Columbia Circuit? Just very briefly, the time within which the challenge can be filed has already come and gone. So if any of you are thinking of challenging this after this presentation, it's too late, but you can participate as an amicus in the future. So what are the arguments? And we're down now into Roman numeral 2C3 of the handout with regard to legal arguments. First, there's an argument that EPA lacks the authority under the Clean Air Act to regulate what's called beyond the fence line of the electric generating unit. So whatever the property line is of a particular power plant, EPA is not authorized under the Clean Air Act to regulate anything beyond that. And here, the regulations require, as a practical matter, a change in the use of natural resources. How natural resources, which natural resources are mined, which are brought to the power plants, and so forth. And therefore, a change in the manner in which the electrical grid itself operates, which takes the regulation well beyond the fence line boundaries of each individual power plant. Under the Clean Air Act, emission reductions have to be made at the source and not at other areas that may impact emissions at the source. So that's the first legal challenge. Second legal challenge is that the Clean Power Plant constitutes improper dual regulation. Here, power plants all over the nation are already regulated under Section 112 of the Clean Air Act, regulating hazardous air pollutants. And there's a specific provision in the Act that says once a source category, such as power plants, are regulated under Section 112, they cannot be regulated under other sections of the Act, and especially not under Section 111, which is what this Clean Power Plant is being promulgated under. So that's the second challenge. Third legal challenge is that there was an improper endangerment finding made by EPA here. You remember that in the aftermath of Massachusetts v. EPA, EPA made an endangerment finding, but it only applied to greenhouse gas emissions from mobile sources. And what EPA is trying to do here is to bootstrap the mobile source endangerment finding onto stationary sources, and in this case specifically onto power plants. And so you just think about the logic. Because greenhouse gas emissions endanger public health and welfare from mobile sources, necessarily greenhouse gas emissions endanger public health and welfare from power plants. As a logical matter, it doesn't follow, but legally, under Section 111, which the power plant regulations are promulgated under, there's a separate endangerment finding that EPA must make. And EPA's position is, well, we really don't have to do that because we can simply benefit from the endangerment finding for mobile sources. One of the practical problems with that is the power plant only regulates carbon dioxide emissions, whereas the endangerment finding for greenhouse gases were for a finding of a suite of greenhouse gases, 6 different kinds of greenhouse gases. Carbon dioxide was only one of which. And so there's just no practical way that EPA can bootstrap a carbon dioxide only endangerment finding onto an endangerment finding that deals with 6 specific pollutants as a category. Next, and I think a very interesting legal challenge here, is there's a specific provision in the Clean Air Act that requires EPA to regulate emissions from numerous and diverse sources under an entirely different section of the Act, Section 108 for criteria pollutants. Here, what's carbon dioxide? Well, it's a ubiquitous natural substance, which incidentally is essential to life on Earth, and it's in everything, and it's everywhere, and it's emitted from everything, including each one of us, which is a major source of carbon dioxide emissions. And so certainly carbon dioxide fits into the regulatory category of emissions from numerous and diverse sources. Those kinds of emissions have to be regulated under Section 108 of the Act as a criteria pollutant and not under Section 111. And so EPA used the wrong section of the Act to regulate. There's a reason for that, because it's a lot more difficult to regulate criteria pollutants than it is for Section 111 purposes. As a matter of fact, in the 45 years of the existence of the Clean Air Act, only 6 pollutants have been regulated as criteria pollutants, and it takes the better part of a decade to do so. And EPA, in its hurry-up offense, primarily because of the talks in Paris and for political reasons, wanted to get this through as soon as possible and knew that the only way it could possibly do it is under Section 111 and not under Section 108. Final legal challenge that I want to talk about is the challenge of federalism, which was discussed previously. And there, it's very clear under Supreme Court precedent that this Clean Power Plan, which requires a change in the mix of resources used in each individual state to generate electricity is overreaching under the 10th Amendment federalism principles of the U.S. Constitution. 1964, the Supreme Court basically determined the national electric power system is categorized by a bright line divide between federal authority over wholesale sales in interstate commerce and state authority over planning, siting, and providing generation resources to local customers. And then in 2013, the D.C. Circuit confirmed that by saying the federal agency may not disrupt the usual constitutional balance between states and the federal government in an area traditionally regulated by states unless the statute is unmistakably clear and compels the intrusion on the reserved rights of the states under the 10th Amendment. Here, if anything, it is unmistakably clear that EPA does not have the power to require individual states to shift their resource allocations for energy production and does not have the power to interrupt state regulation over in-state generating resources. So that's a very brief description of the legal challenges. I want to state just very quickly, because my time is up, that there are some stay proceedings in the D.C. Circuit, and I think that many of you are aware of the fact that a number of petitioners, including many of the states, have asked the D.C. Circuit to put these regulations on hold pending a full resolution of all of the legal issues. And I think, there's a good chance that that's going to happen here. Some of you are familiar with the WOTUS rule, Waters of the United States, under the Clean Water Act. There, the Sixth Circuit Court of Appeals did issue a nationwide stay on implementation of that rule simply because of the enormous economic and political impact of that rule. Remember the quote from Utility Air Regulatory Group. Here, I think because of the enormous political impact, it's likely, but not certain, that a stay is going to be issued by the D.C. Circuit as well. Okay, thank you.
Thank you very much. We have time for a few questions. The microphone will be working its way around. Yes, sir.
In terms of a stay on this ruling?
Need to repeat the question.
Could you, the mic was off. Would you say the question again,
We
sir?
didn't hear.
The Senate discarded the filibuster rule for one reason and one reason only, and that was to place new judges on the Court of Appeals panel, and essentially the court stacked. Does that change the calculation on a stay ruling?
I don't think it does. I don't think that the the composition of the court is going to change anytime within the framework or the time frame of the stay rule. I think we have to take the court as it is now. But what's interesting is, especially in light of this utility air regulatory case of the Supreme Court in 2014, I think that there's a very fair chance that a stay is going to be issued. Given also the fact that the Sixth Circuit issued a stay under the WOTUS rule, and I think it's arguable that this rule is even of more economic and political significance than the WOTUS rule.
Thank you. Next question. Kristen.
Hi, thanks for your presentations. What I wanted to say is just so people in this room are clear, back in November, this foundation held a 2-day conference on this precise subject, the Clean Power Plan. And I would encourage, all of the presentations are videotaped. I would encourage everybody here to watch those, because I think what you're going to hear is that in reality, there simply is no basis for any of this. There's no relationship between CO2 emissions and climate change or anything of the like. So I just find this entire, just the consequences of all this on real people, all grounded in, to me, it's just junk science, I just find very disturbing.
Aaron, did you have a question?
Thank you, Aaron. I joked with the gentleman, Leonard, beside me. I know nothing about this topic before coming in today, but I was interested, Dr. Reed, in the slide you shared, the bar graphs. One of the columns indicated, and I sort of wrote down your words, and I thought it was interesting, there may likely be some power plant reductions if there was a CO2 price. I'm just curious, would that determination of if there would be a CO2 price, would that be determined by Congress? Would that be a decision that the EPA would make? Just curious your thoughts on that.
This was ERCOT, our electric grid, did their own analysis of the final Clean Power Plan, and they essentially gave 4 different scenarios. And so they just ran their models through 2030. And so one was the baseline, what they expect to happen without a CPP. One was if in their model they just put a limit on the emissions. So once a particular power plant reaches that limit, they're no longer able to operate. And then the third was establishing a price. So it was ERCOT. This was just their methodology to come up with what they expected the results to be, and then they looked at things like reliability. And their fourth was also taking into account the regional haze rule, which frankly has a much faster implementation time and probably is of greater significance to the existing coal plants than the CPP itself. So it was ERCOT's own, I was just showing ERCOT's own analysis to make the point that the difference between the current trends and what they say would be needed to meet the CPP really aren't that significantly different. That was the point I was trying to make.
Dr. Shaw, any response?
And I will, just to clarify, with regard to the cost of carbon, that's a very challenging nut to crack, if you will, because as I mentioned, even the impact of this rule, which would be one of the most widespread and large reduction associated with greenhouse gases, even that scale would result, as I talked about, an almost immeasurable change in what's even being modeled. That's assuming the models are correct. In order to put a cost of carbon on, the goal and the way you go about that is you look at what are the models telling you are going to happen down the road, and what is it going to take to put a cost on all those damages that you're ascribing to greenhouse gases in some form. And so it becomes very politicized, it becomes very challenging from a technical standpoint, and I suspect you could probably put 100 scientists in the room and get 100 answers as far as where that number should be that are often orders of magnitude different between those because it is so uncertain.
Do we have one final question? Yes, two questions, and then we'll be out of time. Yes, sir.
Hi. So if you do agree that climate change is an issue and that we do have a duty to leave the planet better than we found it, at the same time, I do agree also that we need to be concerned with the costs and we should be following the law as it is written, not as we want it to be written. With a legislature that's so broken, how do you propose we get to that end point?
Who are you directing the question to? You care?
The entire panel.
You want to go?
I think it's a very good question. It's a question that I think all of us need to ask ourselves. Of course, you know, the scientific and technical issues related to human contribution to global warming are certainly beyond my level of competence. I'm a lawyer. I only look at the legal issues, and you know, I'll leave that debate to others. But from the perspective of the law, I think you know, we have developed a wonderful system in this country of recognizing and protecting individual liberty and rights. And that system is legal based. It's not on the basis of the power of a prince. It's on the basis of checks and balances and making sure that no one becomes an absolute dictator or monarch. When the law says that an administrative agency, which is supposed to execute the law, not create the law, must proceed in a certain manner in order to promulgate a regulation, then we need to hold those unaccountable bureaucracies to account. We need to hold their feet to the fire to make sure that they follow the letter and the spirit of the Constitution and the law. And so that's why, you know, at any time when the government, no matter what the political administration, because as I think was indicated before, you know, you could have a Republican government, you can have a Democrat government, and any one of them, if given unbridled sway, could take us in the wrong direction. That's why we have checks and balances. That's why we have the courts. And so when any government exceeds the statutory powers, it's our job to come in and stop them.
Dr. Shaw?
I totally agree with that. I think I'm more curious about, so what's the proposal for how do we get where we want to go if we assume that climate change is an issue that we need to be addressing?
And if we have time, I'll speak to that.
Dr. Shaw, Dr. Reed, and then I think we're out of time.
Okay,
Please.
I'll try to be brief. I think you've sort of hit the nail on the head of one of the things that I think I have the greatest concern over the approach that's been taken. One, there is still certainly question, in my view, about what impact man's contributions are. Certainly we have seen climate change, and we've seen it throughout history. I think there is evidence that would call into question how much man's contribution has had an impact. In fact, at one point we were told that we weren't really seeing the impact of man's contribution yet, but it was coming. But then we've seen a lack of any significant change in global temperature over the last 18 plus years. Here's where I think we should be coming down as good stewards of the great land we've been blessed with, and that is we should be doing things that are going to improve our environment while improving our economics, because we know that when you have a strong economy, you can afford to improve the environment, and also you raise people's standard of living, you improve their life, you improve their quality of life, you improve their life expectancy. We should, instead of saying we're going to artificially force ourselves not to use these natural resources, we instead should use this as an opportunity to incentivize better efficient use of the resources we have, building toward what sometimes will be renewable energy, but also will include cleaner coal, cleaner gas, cleaner what have you, because one of the natural outcomes of pushing for better and more efficient from an economic standpoint is that we find ways to get more efficient use of the energy we consume. When we improve energy efficiency through encouraging and incentivizing technology, we automatically not only reduce the greenhouse gas emissions, but we also reduce the emissions of other pollutants we may have concern with. And I think that's where the greatest concern that I have is we've seen improvement. We've seen a plan that's working. We don't need the Clean Power Plan. We need to have the Texas plan that's already in place to continue to allow the market to drive us toward cleaner, more efficient fuels that will have the side benefit of reducing greenhouse gases as well as other pollutants of concern.
And I'll just say we've done it before. When we deregulated the market here, we did put environmental provisions. We started a renewable portfolio standard. We started a trading-based system to reduce emissions from the East Texas power plants. And it worked, and what we found is the cost was much less than people complained about. So I think we have examples in Texas of where we've done things which have had both economic and environmental benefits. And of course, I'll argue that under the CPP, we can still do that with a Texas-based plan. So, and the other is obviously energy efficiency, I think would significantly lower any potential cost just by the things we've done, like the Texas building codes, but also increasing our investor-owned utility efficiency programs. I think that would, you know, even if electric rates would go up, actually what people pay would go down just through more efficient use of our energy.
This exhausts the time we have here today, so would you please join me in thanking our panelists today?